5 minutes.
Thank you, Mr. Chairman. Let me make one brief comment on Ranking Member Waxman's opening statement. I know when you're in the minority and the president is of your own party, you have an obligation to defend that president to some extent. I would also point out that we've been trying to get the facts on Solyndra for about 6 months, and it took a subpoena request to finally get some documents, and every member of the minority voted against that subpoena request. Now, last weekend, we got a fairly extensive document dump right at 5 or 6 o'clock, and to the minority's credit, their staff spent all weekend apparently going through the documents, found some documents that the minority felt were worthy of being released, and they exercised their right to do that. And I tip my hat off to them for that. They worked harder, and maybe they were tipped off, who knows, but they at least they took advantage of a situation and did a thing that they thought made sense. You know, Ms. DeGette said in her opening that she wants to get the facts on the table. That's what we're trying to do. There's going to be no lack of witnesses called before this subcommittee from the Department of Energy and other departments. But today we're here to talk to the Treasury Department because they're the department that actually financed the loan. It's not really a loan guarantee. And apparently they're the department that raised a lot of red flags about it that nobody at DOE or the White House paid any attention to. Now, with that, that's my first question. How did the Treasury Department first find out about the Solyndra loan?
About the loan itself?
About the fact that the Department of Energy under President Obama had decided to go forward with it. Were you officially notified, or did you hear about it in the press? I mean, what was the first inkling that they were thinking about giving this company $500 million?
I think the best answer is that it was in March of 2009 when we were submitted documents to provide consultative input.
So you did get an official transmittal from the Department of Energy?
Yes.
Is that a part of the record that we can look at? If not, could we see those documents?
There certainly would be.
Could they be provided?
Emails or other documents that delivered the term sheet and other related documents related.
Chairman Stearns in his questions made the point that in the law we authorized a loan guarantee, which means the private sector makes the loan and the federal government agrees to pay if there's a default. But in this case, this was not a loan guarantee. The Treasury Department actually granted a loan. Is there a decision document that goes through that process and makes that change on the record?
There is there are a number of landing written federal policies, including Office of Management and Budget circulars and other documents, which state that it is the federal government's policy to have the federal financing bank issue a loan when another agency is making a 100% guarantee. And if I could, I'll explain why that has been a long-standing.
So even though the law stipulates a loan guarantee, because there was a decision to do 100% financing, existing regulations convert that guarantee to a loan as opposed to a loan guarantee.
Well, there's still a guarantee that is issued by the Department of Energy. It's just that in this case it is issued to a government corporation, the Federal Financing Bank, which is under the supervision of the Treasury, rather than to a commercial bank.
But in layman's terms, the Department of Energy guarantees that one part of the Treasury will pay the other part of the Treasury if the loan's not repaid. That's what it amounts to.
The Department of Energy is issuing a loan guarantee to the Federal Financing Bank.
So the Treasury will send $500 million to the Department of Energy, who will turn around and send it to the Federal Financing Bank, which is a part of the Department of Treasury. Isn't that correct?
That is correct. And there are good public policy reasons for doing it that way, because it is the cheapest way to finance that loan for the taxpayer.
Now, there are emails, and I think I'm right on this, that the minority has put into the record, or at least released to the public, that shows that many Treasury officials had grave concerns about this loan. Was the Treasury Department ever in a position to just reject the loan?
No. The Treasury Department, neither the Treasury Department nor the Federal Financing Bank would have legal authority to reject the loan.
If asked on the record, or if the President had asked, would the Treasury Department have approved of this loan being given, or would they have objected to it?
I'm sorry, repeat that question.
Well, my time's expired. If you had been given an opportunity, if the Treasury Department had had the authority to say yes or no on the Solyndra loan at the time it was granted, would the Treasury Department have approved it or disapproved it?
One, the Treasury did not have that authority, and two, we did not have all of the due diligence and background information that the Department of Energy had. So it's not our job in the process to make a credit decision or a risk decision.
Is it fair to say that based on objections raised before the loan was granted, after the loan was granted, that the Treasury had grave concerns about this loan? Is that a fair statement?
That's probably not how I would characterize it.
All right, characterize it correctly then.
We provided consultative input on the original terms and conditions. We made suggestions. Some of those were accepted. Beyond that, throughout 2010 and in 2011, we were certainly aware of issues. We were offering advice and input. We were letting the Department of Energy know that we had expertise in finance, in structured finance, and in federal credit policy, and we were trying to make that available to the Department of Energy, but we did not have specific information about the loan or...
I'm trying to help you out.
Gentleman's time has expired. We have a